Hello friends, in the series on income tax cases, today we will discuss an issue in which the assessing officer tries to give a life to an assessment order which was passed in the name of a non-existing entity by passing a rectification order under section 154. The issue before the Honorable Delhi High Court was that whether an assessment order which has been passed in the name of a non-existing entity can be alive by passing a rectification order under section 154. The issue has been taken up by the court in the case of Principal Commissioner of Income Tax versus Vedanta Limited, and this case is reported in 479 ITR at page number 635, and the date of the judgment is 17th January 2025. In the present case, the assessment proceedings were going on and the matter was referred by the assessing officer to the transfer pricing officer. The transfer pricing officer was well aware of the fact that the assessee for which the assessment proceedings are going on is no more and it has been amalgamated into some other company, but in spite of that, the transfer pricing officer passed the transfer pricing order in the name of a non-existing entity, and on the basis of that TPO order, the assessing officer passed the draft assessment order in the name of a non-existing company by writing in the bracket that this company is formally known as C, meaning thereby that the assessing officer tried to confuse the concept of amalgamated company with the concept of change in name. Ultimately, the assessment order was passed in the name of a non-existing entity, and this was the assessing officer tried to rectify that mistake by passing the order under section 154. When the matter was before the tribunal said that in the present case, one fact was very clear, that both the transfer pricing officer and the assessing officer was very well aware that the company is amalgamated, the company does not exist. The tribunal said that section 292B gives shelter to the revenue in those cases where some clerical mistakes are there, where are some accidental slips or omissions are there, and where that slips do not go to the root of the matter or substance of the provisions of the Income Tax Act. Only those omissions and slips can be rectified by taking the shelter of section 292B, and the tribunal said that section 154 is only helpful for those omissions which are of the nature section 292B, meaning thereby that the section 292B and section 154 go hand by hand, and only those mistakes which are only of accidental nature can be rectified by section 154. The tribunal said that since in the present case the assessment order has been passed in the name of a company which is not in existence, and just by writing that it is formally known as C company, that non-existing order which is made in the name of a company which is no more and which has been amalgamated cannot be rectified under section 154. Friends, this case is very important because in the present case, it was very clear from the facts that the order has been passed in the name of a non-existing entity. So, if we go by law, that order do not exist. So, if the assessing officer tried to rectify that order, then that will not help the assessing officer, because according to section 154, only that order can be rectified which is actually legal in nature. So, any assessment proceedings which have culminated into an assessment order in the name of a company which is non-existing, so that assessment order is very much bad in law, and that cannot be given life by taking the shelter of either section 292B or section 154. Friends, this case is very important because it just gives a clear message that whenever the revenue takes the help of section 154, so they try to bring each and every mistake, whether that of jurisdictional mistake or whether it is a mistake which goes to the root of the matter, by covering it as a mistake apparent from record. But when the assessee files some section 154, then in those cases all the rectifications applications are generally rejected sole on the ground that the matter does not involve the matter which are related to apparent from record. So it is a very harsh thing, although it happens in very usual course of action in the assessment proceeding. So in the present case, Delhi High Court very categorically said that section 154 cannot come to the rescue of the revenue to give a life to an assessment order which has been passed in the name of a non-existing entity. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Vedanta Limited, and this case is reported in 479 ITR at page number 635, and the date of the judgment is 17th January 2025. Thank you, friends.